Learned counsel for the appellant has argued that once there was a valid insurance policy operating as on the date of accident, documents in relation whereof were duly produced before the tribunal, there was no reason or justification for the tribunal to have recorded a self-contradictory finding in the award to the effect that the offending vehicle was not insured as on the date of accident. As such, the said finding is perverse. This court, in order to test the submissions advanced, has gone through the original record summoned before this court, and it is found that a copy of the original policy bearing premium receipt number as on 24/6/1999 is on record. Once the original policy is in the list of documents filed before the tribunal, then in such a situation recording a contradiction oblique contradictory finding to raise a doubt about the validity of insurance of the vehicle on the relevant date is clearly erroneous and baseless. The contradictory finding recorded by the tribunal that the vehicle was not insured being perverse is hereby set aside, and the vehicle is treated to be covered under the insurance policy, particularly when the same remained unquestionable. Recording of a finding in relation to insurance policy in favor of the owner appellant herein goes to establish only one ground, but insofar as the other ground of driving license and its validity is concerned, the same being decided against the appellants is strongly contested by the insurance company represented by Sri Sachin Kushawa, learned counsel. The tribunal, while deciding the claims, has found that though the photocopy of the driving license is said to have been issued on 12/5/1986 was placed on record, but the date of its validity was not legible, which lead to a doubt for recording or a finding in favor of the appellant. It is worthwhile to mention that the driver of the offending vehicle has not participated in the proceedings, and the original license was also not filed before the tribunal so as to clear the doubt which was noticed on the photocopy of the driving license. As per the stand taken by the insurance company in its written statement filed before the tribunal, the validity of the driving license was disputed. The issue framed on this aspect of the matter was duly gone into by the tribunal, which appears to be assailed before this court baselessly and without bringing on record any prima facie or conclusive evidence on the basis of which this court may come to a different conclusion. During pendency of these appeals, an application for disposal of interim relief application was however filed on 5/9/2014, and some documents were placed on record along with the said application, which includes the document alleged to have been obtained by the appellant under Right to Information Act on 9/12/2009. The said information relates to the driving license, indicating its validity as on the date of accident, but the information is seriously disputed by the insurance company.